Woodruff is a case which surprisingly did not take place in Atlantic City. But when you realize that it did involve guns or drugs, it's not surprising. This was an East Windsor case. This is important. This is an important case because one of the most common reasons for a stop, at least with DWI, is not so much speeding, although certainly that's always a justification, but because Mr. Woodruff left his lane twice. That is, he went over the fog line, if you don't mind me calling the right-hand line on a lane of travel, closest to the shoulder, separating the shoulder from the roadway, the fog line. His vehicle went over the fog line twice, up to the width of half his vehicle, and the officer pulled him over. His argument was that he did not violate 39:4-88 in that he, which requires that you maintain a lane of travel as practicable as possible and not change lanes until you can do so in safety. Now, I have some experience in this, both driving and otherwise, in that I argued before the New Jersey Supreme Court about 10 years ago, 39:4-126, which says that you shall signal before changing lanes if you can't do so if you can't change lanes safely. Now, what the Supreme Court held in that case is this: if you're driving a motor vehicle and the movement of your motor vehicle from one lane to another may, not will, but may affect another automobile, you have an obligation to use your blinker. As simple as that. This case, the statute that we're dealing with here, talks about maintaining a single lane of travel. That's your first obligation, wherever practicable, to whatever degree practicable. And if you are to leave that lane, not to do so until you can do so in safety. And then 4126 would say, and if you can do so in safety, but other vehicles may be affected, they may step on their brakes or slow up or be more aware, then you have to use your blinker. Now, no one has ever defined what that means to travel within your lane as practicable as possible. And Woodruff, which is only a law division case, looks at all the other jurisdictions around the United States that have interpreted this statute. You should know that this statute that New Jersey has is part of a national uniform statute. This statute is repeated in the majority of states verbatim. So when other courts are interpreting this statute, they're interpreting the exact same language with the exact same police officers that we have here, with the exact same driving conditions. So it's interesting to see what other courts say. What they say is this: you have to look at all the circumstances. If a car were to make a sudden movement, a jerky movement, and then jerk back, that may be reason to pull that car over. On the other hand, if a car that's going over a long distance, from time to time will drift over and just touch the line, or even go over it a little bit where there's no cars in the oncoming direction. You want to know something? We're not judging them, the court goes on to say, by the perfect driver. We're talking about the reasonable and practicable driver. They're also talking about the fact that a sudden change within your lane, that you go into the other lane and jerk back. Well, do you know what? Sometimes that happens if you're tuning the radio, if you're changing the CD, if you're smoking a cigarette and you drop it in your lap, if the kids in the back are screaming and you do what every father does. If you kids don't, calm down, I'm going to turn this car around and go home. Meanwhile, that's so that they'll be safe. Meanwhile, your eyes are off the road. You're looking in the back seat. What the court says is this: if your car jerks from the lane but comes back, in rush hour traffic, that may be a very good reason to pull you over. But if you're in the middle of, rural country and it's nighttime and there's no other cars on the road, that may not be a reason to pull you over. If you drift over up to and touch the center line and just over it, and you've been traveling for 2 miles and there's no other cars around, that's not a real good reason to pull you over. The reasonable, practical driver, if he knows there's no oncoming traffic and he's alone on the roadway, he doesn't need to maintain that lane so perfectly that if his left wheels touch the center line and go slightly over, that makes a difference. However, at rush hour, that may make a difference. And if you go halfway over the fog line, that may make a difference. In this case, the court found that there was probable cause for pulling over this vehicle because it went over the fog lane twice with the width of half its vehicle. Now, in truth, you have to ask yourself the question, is he really posing a danger? No, because it's the shoulder. You can usually see a long way. You can see there's no one else on the shoulder. On the other hand, what does that say to you as a police officer? This man's going over that fog line, half the length, half the width of his vehicle, and he's now done it twice. This isn't just a CD, a cigarette drop, or a sneeze, or a bee flying in the car. There may be something wrong with this driver, and that's not normal driving. And that's what it really comes down to. Is this normal driving? Is this the kind of mistake that I can make? Yeah, I'm not paying attention for a second. I go out of my lane once, or I touch the sideline. We all do that. But we don't drift over the shoulder twice for half the length of the car, even for a brief period of time.